You have to really take the battle to your opponent and put them on the defense. My name is Michael Waddington, and I'm a military defense lawyer who represents military members that are being administratively separated and facing boards of inquiry. Now, when it comes to calling witnesses at a board, you have the right to call witnesses. As with everything with the military and with the government, you have all these rights, but then there's always rules and regulations. Like you have the right to bear arms, but often they put all these rules into place that starts to impact and cut down on your rights. So yes, you have the right to a lawyer, and yes, you have the right to go in there with witnesses. However, some branches will do nothing to help you get the witnesses, even if the witness goes to prove your innocence. Now, for example, you have 5-6 witnesses over at the company area, and the company knows your board's coming up, and you're going to lose your retirement potentially. And you tell them, hey, I want those witnesses. They're crucial to my board. The commander and the prosecutor / recorder could be like, nope, they're going out in the field, no phone access. Too bad, so sad. That is not uncommon for them to do that. So you need to know who these witnesses are. It's a good idea to get a civilian lawyer to get ahead of this. Make sure you lock down testimony of witnesses that are not going to be available. You can do that a variety of ways, which I'm not going to discuss in this video, but there are ways to get that done to preserve that testimony. If you call the witnesses, what you end up doing is having to get those witnesses on your own, which means that the witness hates you and they don't want to testify. They could duck out and not show up, and there's nothing that can be done about it. You can sometimes ask the board to produce these people and make a compelling argument. I've seen some boards order people to show up and testify or call them on the phone, but in most cases, the board doesn't care. Whatever they have is what they have. Another right at the board is to cross-examine the government's witnesses. That sounds like a great right, but what if they don't bring any witnesses? That's another little tactic I've been seeing recently. You show up for the board, and the alleged victim who's accusing you of sexual assault won't show up. They'll send their lawyer in their place. The lawyer will be there for the board. The witness will be nowhere to be seen, but then that lawyer will submit a statement on behalf of the victim, and you cannot cross-examine them on that. So you end up with this long, like over-the-top statement about how bad you are, how you victimize them. It's being read to the board, but you can't question the victim. It's always a good idea to argue how the standard is preponderance of the evidence, and they have a duty to present evidence to that standard, which isn't low. It's the same standard if you're suing someone in a civil case for $1 million. You capitalize on the fact the witness didn't show up. They had the opportunity, their lawyer was there, they've never been questioned, they've never been confronted, so therefore you argue their testimony is not worth as much, their credibility hasn't been tested, their integrity has never been put on the line. That being said, some board members don't care. They think victims don't have to testify, they're pro-victim, and if that's the case, you're in a tough spot when you're fighting a board in front of people that are biased against you and pro-victim. However, you have to make the record, meaning that you have to put on the case you can and fight with what you can. You have to have impeachment material ready to go. You don't walk into the board thinking everything's going to go as planned, because it's never going to go as planned. You have to really take the battle to your opponent and put them on the defense. You should be aggressive at boards while not alienating and upsetting the board members. If you're facing an administrative separation board, then call today to speak with one of our lawyers to discuss your case, your rights, and the best way forward to fight for your future and your career.